There we go. Everyone will be getting started in just a moment. Welcome, everyone. My name is Skip Harsh. I am the director of the Commission on Sexual Orientation and Gender Identity. We are very excited to have you here today for this important webinar entitled Location, 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 Fairness and Access in Conference Site Location. I'm joined today by Joy Lingar, who is the provost of the National Judicial College. Unfortunately, our fearless leader, Benis Aldana, was not able to join us last minute because he is en route to Washington, D.C. to attend an event with the vice president. And he expresses or gives his apologies for not being able to join us, but we are in good hands with Joy and our other two panelists. So we hope that you will find this program informative. If you are planning on asking questions, and we very much hope that you do ask questions, please utilize the Q&A function. We have disabled the chat for attendees for technical purposes. If we need to relay any messages to all of you, like links or anything like that, we will do that in the chat. But otherwise, please utilize the Q&A function for any questions and or comments. And with that, I am going to stop my video and turn this over to Joy and the rest of our panelists. So thank you, and from Soji to all of you, have a wonderful program.
Thank you, Skip. It's great to be with you. My name is Joy Lingar. I'm the provost at the National Judicial College in Reno, Nevada. And Benis Aldana is not only the chair of the commission, he's the president of the National Judicial College and my boss. So when he asked me to step in, I of course said yes. He may be tuning in from the airport, in fact, on his way to DC. I'm honored to be here. I'm grateful for the Commission on Sexual Orientation and Gender Identity for offering this important webinar, and to its director, Skip Harsh. Choosing a location for your in-person meeting is an extremely important decision, and you must consider many factors when you choose what city or state to go to. So there's many organizations and entities that are struggling right now with the issue of whether to hold in-person meetings in cities and states that have laws that discriminate against an identifiable population or individuals. This webinar will be an opportunity to learn about the laws and provide an honest conversation about whether ABA entities should hold meetings in cities or states that have discriminatory laws on the books. This webinar is not meant to act in a way to try and change the ABA policy, but rather educate ABA entity leadership as to the unique issues they will face when selecting their meeting locations. As Skip said, we would love to engage with you. Please think about the questions you have for us and send them in using the Q&A box, and Skip is going to be monitoring that Q&A inbox. We've got two speakers here with us today. I'm going to tell you, introduce them both to you now and then turn things over to Mark. But we'll first hear from Mark Page, who's the Director of Meetings and Travel with the ABA. He's going to talk about the ABA's current policies and procedures, and then we'll go to Judge Kristen Rossi, the Chief Administrative Law Judge with the California Department of Insurance. She's going to talk about her experience with these issues and why it's important to take this matter into consideration when deciding where to hold your next meeting. So let's go first to Mark Page.
Thank you, Judge Lingar, and thank you so much for having me today. I see so many familiar names in the participant list, and some I don't recognize. So I'm going to start by just explaining who I am for those of you in the program today that don't know me, I'm Mark Page. I'm the Director of Meetings and Travel at the American Bar Association. I head up the sourcing team that plans or does site research and makes recommendations for all of the ABA entity meetings that occur throughout the year. And of course, I'm going to speak in terms of a pre-pandemic year, what's normal, quote unquote normal for the meetings and travel department. Up to 300 entity meetings are booked in a normal year. That said, that represents $16 million in rooms revenue for the meetings industry and to the hotels that we source. Our top brands, not surprisingly, are the big box brands, the Marriott, Hilton, IHG, which is International Hotel Group, Accor, which those of you might think of Fairmont hotels in that group, and Hyatt. That sourcing team is extraordinary, and we're all very much relationship people in the meetings industry, and have a lot of experience in negotiating and getting the best deals for the American Bar Association and our members. I also staff, and I think this is important to point out, the Standing Committee on Meetings and Travel, because the Standing Committee on Meetings and Travel makes recommendations to the board on where to hold future annual and mid-year meetings. So I kind of like set that up that way very purposefully, because I want to point to the policy that's in the Green Book that kind of guides what we do, and the policy that we follow for annual and mid-year meetings. And that is, the association does not use the criteria of whether a meeting site or jurisdictions in which the site is located supports, opposes, or is neutral upon any policy adopted by the association when selecting locations for mid-year and annual meetings. The association neither supports nor opposes boycotts of meeting sites. That's the ABA policy. I also purposely talked about the relationship importance that the team here at the ABA has with the hotel partners. And that's beyond just the sourcing teams here. That's the entities that have planners that also are very heavily involved in helping locate sites for future meetings. And I've always had, and I've been kind of quoted on this in the industry some as well, I've always said that there are only 80 of us that work in the industry. We just keep moving around. So it's important to understand that, because the person that you're working with at a Hilton hotel today, you might have worked with 20 years ago at a Hyatt hotel in another capacity. Someone that's working at the Seattle Convention and Visitors Bureau today might have been at the Indianapolis Convention and Visitors Bureau before. So it's interesting because relationships are absolutely everything in our ability to negotiate terms and concessions for our contracts. And the policy as such, and I know what we're talking about today, as teed up so brilliantly, is we're really talking about, in this example today, 18 states that have the discriminatory laws that are concerning. I am an LGBTQ member, card-carrying member, and I appreciate very much and understand exactly what we're talking about today. And I'm going to leave my comments there, because I have a feeling once we're kind of through the rest of the presentation, you may have more questions, and I'm happy to field those as they come in. Thank you so much. And I think that I'm going to pass it to Judge Rossi, who's going to talk about some practical examples.
I didn't know that there was a card. I didn't get the card.
There is.
There's a card. I'm going to look for mine in the mail. So thank you, Mark, and Joy and Skip, and for the ABA for inviting me to share some thoughts on this issue, along with my experience, our experience with the National Association of Women Judges, which I'll talk about a little bit later. I think before talking about the extraordinary leadership that NAWJ has taken in this arena, it makes some sense to discuss the why, meaning why are we having a conversation about meeting locations? Why is this important? And perhaps it's a no-brainer right now as anti-LGBTQ laws are making headlines around the country, laws affecting women's rights to healthcare and access are making headlines around the country. But the magnitude and the breadth of these laws is important. And I think we need to talk about that, as well as the response that some state legislatures have had. So as Mark mentioned just a little bit ago, currently there are 18 states with anti-LGBTQ laws on the books. The scope of those laws range from legislation prohibiting LGBTQ individuals from adopting children, to laws banning changes in gender markers on birth certificates, to the trans sports bans that we've heard about, to the so-called bathroom bills in Tennessee and North Carolina, to Florida's Don't Say Gay bill, which has made a lot of headlines recently as well. And it should be noted that Alabama and Mississippi have very similar laws to Florida's on the Don't Say Gay. We're nowhere close to seeing an end to this trend. Conservative states have introduced 238 new anti-LGBT statutes in 2022 alone. We see daily attacks on women's health from many of these same states. And what we know to be true is that the assault on equality and access isn't going to stop anytime soon. So the question then becomes, how do we respond to these attacks on diversity and inclusion? And what do we do about our membership organizations when we ask people to travel? So some state legislatures have responded by passing laws to ensure the safety and dignity of their employees and their citizens. For example, in 2016, California legislature passed AB 1887. And I will, in full disclosure, say that I'm in California. AB 1887 prohibits state-sponsored travel to any state that enacts laws discriminating against the LGBTQ community, or repeals any existing protections for LGBTQ people. So that law also requires the California Attorney General to develop a list and maintain that list on the state's website, so that everyone knows which states are included. It's something that all state employees know. I can tell you as a state employee that when you wish to travel, that list is consulted by everyone before you're allowed to travel. Similar laws exist for state employees in Washington, although I think they lifted theirs in 2021, Minnesota, New York, Vermont, Connecticut, and then city and county employees in San Francisco and Los Angeles also have similar laws that restrict their ability to travel to many of those states that you see. And so, while state legislative responses are an important step, we also know that it really doesn't go far enough in protecting access and fairness for everyone. And that's where associations and organizations, I think, need to step up and step in. Joy, I guess if you'd like, I can talk a little bit about my experience with the National Association of Women Judges.
Yes, I think
unless Mark,
the perfect time for that.
Okay, unless Mark, you want to jump in, Mark, I can keep going a little bit.
No, thank you.
Okay. So in early 2021, the National Association of Women Judges, which I'm going to refer to as NAWJ for simplicity's sake, because National Association of Women Judges gets hard to say over and over again. But the NAWJ's LGBTQ committee undertook an effort in early 2021 to provide conference access for all NAWJ members. In part, this effort was spurred by NAWJ's plan to hold its 2021 annual meeting and conference in Nashville, Tennessee. As I mentioned before, Tennessee has a particularly onerous bathroom bill, which requires that a trans person use the bathroom that corresponds to their gender assigned at birth. Failure to do so constitutes indecent exposure under the statute and opens you up for criminal liability. As an organization with trans and gender nonconforming members, the LGBTQ committee believed that holding meetings in such states was inconsistent with NAWJ's mission statement, which says that we ought to be advancing diversity and inclusion in all areas. So the committee drafted and presented to NAWJ leadership a resolution that would bar NAWJ in the future from holding any mid-year or annual meetings or conferences in states that enacted anti-LGBTQ laws or repealed LGBTQ protections. The resolution referenced the California Attorney General list, in part because it was an objective measure of what constituted anti-LGBTQ legislation. It also meant that we weren't constantly being asked to review that list. And so we presented what we believed at the time to be an incredibly straightforward and simple resolution to NAWJ leadership. You know, as an organization, we had vowed to prioritize and advance equity and inclusion, to eliminate bias, enhance diversity. So certainly we thought we should not be forcing members who wish to fully participate in the organization to travel to states where their mere existence was criminalized. But candidly, it was not simple. It was not easy. It was at times painful. It was at times heartbreaking. And I believe that it changed many of those of us involved and the organization as a whole. It was a long struggle, a 10-month struggle to even get a vote of the full membership on this issue. And when the final vote was taken, it was a very close vote, and the resolution passed by only 4 votes. So if you don't think that your vote matters when you vote, it certainly does. And I guess I want to say this about the struggle, and I call it a struggle because for the LGBTQ members of the organization and their allies, and there were many, many allies, that it was hard, and as I said, it changed us. I believe that many of the people opposed to the resolution were well-meaning, and I believe that many of themselves considered themselves allies of the LGBTQ community. But if we've learned anything in the last couple of years, it's that allyship is hard, and respecting each other's differences and believing each other's truths is both necessary and difficult at times. It requires listening, and it requires respecting the voices of those in front of you when they share their painful experiences and their fears, and that is difficult, and it proves difficult to all of us. But in the end, NAWJ did something that it ought to be extremely proud of. NAWJ took the lead and said no to intolerance, to oppression, to discrimination, and it became the first judicial organization to say we will not place our members in jeopardy. We will not travel to places where access and fairness and equity inclusion, the things that we stand for, are legislated against. And I'm happy to share more of that story if folks want it, but perhaps we can start there.
Thank you, Judge Rossi. So I want to just encourage folks to use the Q&A tool if they have any questions that they would like me to pose to our speakers today. We got one question, maybe for you, Judge Rossi. Does the California law also limit travel to states that discriminate against women's health?
So not yet, not yet. You know, I think, well, I as a California resident and as, you know, someone who is paying attention, I guess, to these issues, I don't think that it would be unheard of to see that coming down the line. And I think that the governor has already signaled that he's going to be doing things to protect women's access to healthcare. You know, the threats to women's reproductive health is you know, a fairly new one now. You know, the laws that that started the AB 1887 discussion, you know, began back in 2014, 2015, 2016. So at the time, the California legislature was responding to what it was seeing from these states regarding anti-LGBTQ legislation. I think that it is not, it would not be shocking if the California legislature took a similar response to access to for women's health in the future. I mean, I don't know of it, but I think that we shouldn't be surprised, and I think that is an issue that organizations are going to have to tackle, whether it's the ABA, whether it's NAWJ or some other organization, and you know, and to that end, I think that many of this, if you were to look at a list of the 18 states that California employees are not permitted to travel to, you would find a lot of crossover between those 18 states and the states that may be restricting access to healthcare. So I think that that's something that is teed up for sure. And I think it's something that organizations are going to have to deal with, just like the LGBTQ issue.
Thank you. Mark, I have a question that may be best answered by you. You know, especially larger events or conferences, folks are having to contract for those sometimes years in advance. Have you seen any creative use of contracting or clauses to prevent an organization from being tied to hold a conference in a state that may end up with a law on its books at the time of the conference?
That's an interesting question. We at the ABA, as you can imagine, we have our own hotel contract that we use with the different hotel brands. Some of them, you know, in cooperation with our general counsel's office and our sourcing managers, they've evolved a little bit, but there is nothing in our ABA contracts that would permit, you know, a cancellation, for example, of a meeting because a new, you know, piece of legislation was passed or a new law was passed that would be objectionable to any group. This going back to the simplicity really of we just don't boycott meetings in any state.
Mm-hmm. Yeah, we've just kind of wrapped our heads around what to put in there, what language to put in there around COVID. So I don't know that we've got all the clauses nailed down that we need. Judge Rossi, I wondered if you could share the link to the California AG's website where they keep that list maintained. And do you feel like that is the best place for people to find the latest information?
I can't share the link. I can share it in the chat, and then I think that maybe we can share it out to everyone else, since I think only we can see the chat. And so I will do that. It's actually fairly easy to find. If you go to the California Attorney General's website, there is a section on equality for LGBTQ folks, and it is highlighted right there, as well as the list of 18 states. So, you know, there are states that are not on the list. The list is being constantly updated. I will tell you that in the midst of our work at NAWJ in 2021, the list was not 18 when we began presenting the resolution to the leadership. And in fact, I think 4 or 5 states were added to the list while we were presenting this to NAWJ members and holding meetings to discuss the issue and why it was important. And so we had that sort of constant flux. I don't know how often the Attorney General's office is actually updating the list, but we did have 4 or 5 states added in 2021. And Florida was actually one of those states that was added in 2021 before the Don't Say Gay. So I know that it is updated. Do I believe it's the best list? I think that there are some states that aren't on that list that perhaps may end up on that list at some point. I know that there are some laws in Virginia, for example. Virginia is not on the list, but there are laws in Virginia that many consider to be discriminatory against LGBTQ folks, and they're not on the list. So I don't entirely know how the Attorney General chooses it, but we at NAWJ linked the resolution to that list because we felt like someone was monitoring it. It was objective. It meant that NAWJ didn't have to be constantly reviewing, every state's legislature to see what was going on before they chose a conference selection. And it also meant that the LGBTQ committee didn't have to do that. And I should say, in full disclosure, I chair the NAWJ's LGBTQ committee and sit on SOGI, which is probably why I was invited to be here today. Yeah, we tied it to that because it's objective and it didn't require us to do more, and we knew someone was monitoring it. And I actually I think that there was a question about whether any other entity is doing this. I mean, certainly, I think you can expect the LGBTQ bar is not going to be holding, Bar Association is not going to be holding conferences in any of these 18 states. I don't know that there are any other legal organizations or judicial organizations that are doing it. There are non-legal entities that are doing it. I know that when the bathroom bill was passed in Tennessee in 2018, 2019, that and actually it might have been before that. So in addition to the bathroom bill, Tennessee also has a law that allows mental health clinicians to discriminate against LGBTQ folks and in fact to discourage an LGBTQ lifestyle. And so the American Counseling Association was set to hold their conference in Tennessee in 2019, and they actually moved it out of Nashville, citing these laws that they felt went against the ethics of the association itself. So, and I know that there are some folks, of course, and when North Carolina passed its bathroom bill, there was, backlash from a number of entities, from the NCAA to other groups saying we're not going to North Carolina. But I don't know that there's any other legal or judicial organization that has taken the leadership step that NAWJ has.
Thank you, Judge Rossi. I guess I can speak just briefly on behalf of the National Judicial College to say we don't have a strict policy in place, but we do take this issue very seriously, and we have a lot of conversations about where we take our courses. We're a little bit different. We're not a membership organization. We have kind of a workshop style courses that we hold around the country that usually have about 40 people at each. So we know we're not bringing, an incredible amount of money into any specific city, but we do have courses that are designed that fit best in certain cities. So as an example, we have a course called When Justice Fails, Threats to the Independence of the Judiciary. And we wanted to have that course in the context of the civil rights. So we took it to Montgomery, Alabama, so that we could take the participants to the National Memorial for Peace and Justice and the Legacy Museum. And we also wanted to make that course available to the judges in Alabama. So that's one of the lenses we look through when we're trying to decide, do we have a good reason to take a course to one of those states that's on the list? So let me just go to the Q&A box. We do have one question here. Is there a difference between how legal organizations should consider holding events in states with anti-LGBTQ legislation and other state law issues such as voter suppression? Any comment about that question?
You want me to go? I'm going to make Mark go first.
Thank you. Well, I tell you, it is interesting because, you know, with the number that we're talking about here, just in the example of the description of this course, 18 states is 36% of the states. If you start layering on other very good reasons that people might want to not meet in specific areas, we're going to quickly run out of places to go. Unfortunately. And interestingly, I don't think I very clearly answered Judge Lingar, the question that you had about the contracting for future meetings. I'll tell you, we're in a really tough spot right now at the ABA. It's funny because we used to, pre-pandemic, be in the catbird seat. I mean, one of the largest, if not the largest association client for most of the hotel brands. But as we have, you know, experienced COVID, we have been rebooking and rebooking and rebooking the same meetings over and over again. And a lot of times to avoid tremendous, and don't get me wrong, this isn't all about money, but to avoid tremendous financial exposure, we have to be creative, and we sometimes have to work with the brands to put large meetings in, you know, wherever they will have a footprint where they will fit. And it's interesting because that may not necessarily be the city that they started in. And you think about states like Florida, for example, there are a lot of large hotels there with a lot of meeting space. And so sometimes, you know, even when entities, for example, understand and know, a good example is the recent law that prevented us from getting CLE credit for our attorneys that, you know, our member attorneys, 7,000 of them that were in the state of Florida. We couldn't get CLE credit for programs because the ABA had the policy that, you know, our panels had to be diverse. I mean, we've got 350,000 members. We certainly can diversify our panels, and the State Bar of Florida followed that, and then suddenly it became this thing that we all know about, I think. But it's interestingly, there are entities that, even though that they knew that, our sourcing manager would point out when we would see a request come in for, you know, a state that was, you know, in such flux at the time, they would get with their leadership, and the leadership would come back and say, well, we're not really doing CLE, this is kind of different, and kind of fall back on that. You know, historically, Florida, for example, is a very popular destination, and they have a lot of hotels with a lot of meeting space. So it is interesting. It's that's the long answer to, you know, should we consider holding events in states with the anti-LGBTQ discrimination laws? Because the other thing too, I want to make sure that I get in there, is these things can change. Sometimes they change for the better, like the CLE credit in Florida. If we had canceled all the meetings, for example, because of that, we would be in a, you know, an even tougher spot than we are currently in finding space in Florida, because it's popular, and, you know, the meetings are booked so far in advance now. It's difficult to find space.
I kind of wanted to piggyback on that to say, you know, some of these meetings are worth hundreds of thousands of dollars to the hotel, to the community. If we're making those decisions, I think that one of our purposes is to put a little bit of pressure on that state to make sure that they know that they're losing some potential revenue. Do we have any mechanism for making sure the state knows that?
Interestingly, that kind of happens organically with our relationships with our CBP people. Remember the 80 rule I was talking about? So our contact, who used to be the VP at Choose Chicago, went to Miami and now works in Miami. Okay, and then I get a phone call, Mark, why aren't we seeing business for Miami like we used to see? And that was a very good conversation. That was a good conversation opener and an opportunity for us to kind of explain and help guide the people that understand the meetings industry and what that dollar value of the business means to the meeting industry, and do what they can to kind of twist the wrist a little bit. In that particular case, they were fairly powerless because of the laws in Florida, and what was causing all of this. But that's just one example.
Great, thank you. We've got a question in the Q&A box. What do the panel?
Can I jump in really quick before we ask the next question?
Yes.
Because I think what Mark is talking about is really important, and I want to make it it clear that for the NAWJ, it wasn't an issue of money, right? It wasn't an issue of how much revenue we were bringing into these states, because it's not the ABA with 160,000 members. It's an organization that maybe has 200 or 300 people going to its annual meeting or conference, and so it wasn't that we intended or even expected to be making a financial impact with the resolution. The resolution was really intended and is intended to be a statement about access and full participation in an organization by the LGBTQ members. And that and what I mean by that is that if you're going to knowingly hold a meeting in states that is actively discriminating against LGBTQ folks, especially trans or gender nonconforming members of our organization, then what you're asking them to do is to go to a place that in many cases criminalizes their mere existence. And you're saying, in order to fully participate with this organization, you need to come here and you need to do this. And we felt like it was not in keeping with what the mission of the organization was. The NAWJ was founded by, 40 plus years ago by some groundbreaking female judges whose first resolution when they got together some 40 years ago was to pass a resolution urging the adoption of the Equal Rights Amendment. That was the first thing they did when they got together. And we felt like as an organization that respecting equity, access, diversity, inclusion meant that we had to allow everybody to fully participate in the organization. And that really meant that we shouldn't and we ought not to be engaging or encouraging folks or asking members to go to places where it's just not safe to go. And so for us, it wasn't about the money. It was really about access and fairness and safety and what it means to ask a member of the LGBTQ community to go there if they want to fully participate in your organization. And the other thing I want to say is, yes, 18 states is 36% of the country, but many of those 18 states are not states that NAWJ and probably the ABA would ever go to. In fact, I believe somewhere between 9 and 11 of the states on the list, NAWJ doesn't even have members in those states. So we wouldn't have held conferences in those states anyway. And my sense is that's probably also true for the ABA, that there are fewer members in many of these states. And so, it sounds like a big number to say 18, but really we're talking about a handful of states where we were gone. And certainly Florida, Texas, Tennessee, those states are on the 18, right? And so we were really talking about, from an NAWJ perspective, a small handful of states because we weren't going to go to all 18. So I just wanted to throw that in, but
Thank you, Treasurer. I think that's really important.
Spar with Mark a little bit.
Yeah. Remind us of the purity of the intent, but I think nobody minds if there's some economic repercussions for the states. And Mark, you flagged a question you want to answer, and I only see part of it. So I'm going to let you ask the question and then answer it to give you double duty here.
Did I flag something?
I've got, well,
Right.
It does say, so Mark Page would like to answer
Sounds
this question live. Yeah.
I click buttons all the time. I don't know what I'm doing.
Okay. Well, did you have, there is one question that came in. What do the panelists think about linking event contracts to federal discrimination statutes? Do you want to take a crack at that one?
Sure. So again, that kind of goes back to my previous comment about how the ABA currently doesn't boycott meeting sites, and for the reasons, I mean, I'm in this very weird spot here where I have my personal opinion on things, and then I also understand, like, we're running a business here. And also that, one of our goals and objectives, not objections, I would object executives, is to, eliminate bias and enhance diversity. So I don't know that we're in a position of drawing that sort of clause into a contract at the ABA, certainly. Did that answer the question?
I presume we'll hear if it didn't. I was going to say, ask a follow-up. It doesn't cover everything. So here's an interesting question. It seems that by going on the record about these issues, we might risk some backlash from states. Florida, for example. Wouldn't it be better to just quietly have leadership in our sections work to select friendly jurisdictions and stay away from the unfriendly ones?
Sure, in a perfect world, that would be great. I mean, yes, that would be great. And I can speak from the NAWJ perspective, and that is that when Nashville was chosen as a conference an annual meeting site, the anti-LGBTQ laws were in existence at the time. But there was perhaps no one on the site selection committee that understood that, or there was no LGBTQ member on the committee. And so there was no one to raise that issue. And so I think that's tough, because it means that you've got to have people knowledgeable about all of these issues, and we know from experience that didn't happen, and I think it's difficult to because that did come up at NAWJ. Well, can't we just sort of have an underground rule that we won't do that? And we could have, except that people come in and out, right? And of organizations, and not everyone, and sometimes institutional knowledge is lost, and that really requires everyone to be sharing all of these things. And also I think in the case of NAWJ, coming out and saying this is who we are and this is what we stand for is actually a membership attractor, right? I think that it actually makes the organization, it says the organization is going to walk the walk, that we're not going to just say that we believe in access and inclusion. We're actually going to show you what we mean by access and inclusion. And we're going to take a stand. And I think that that's a powerful thing, especially now when access and inclusion on women's rights, voter suppression, all of these things. And again, many of these same states are all the same states. You know, I think that saying that we mean what we say and we say what we mean is attractive. I think that it doesn't actually hurt.
Great. Well,
Skip came on.
Skip, maybe you
I know
can
I wasn't planning on it, but this question really speaks to the heart of, I think, why we wanted to host this panel in the first place. You know, and Dennis probably would articulate this. We all have our own personal opinions. You know, Kristen, you know, you wear yours on your sleeve. I think Mark and I are maybe a little bit more cautious, but you know, what we are trying to do, you know, right now is educate our leadership, our entity leadership, and our entity staff, because of the realistic, you know, the understanding that trying to change ABA policy is going to be very, very difficult. So we have to educate, and that sort of leads into another question that was asked, and that's, you know, what we can do, you know, what suggestions we might have for the section divisions forms when they do hold a meeting in a certain state with discriminatory laws, and, you know, they want to try and make an impactful difference. And that's the conversations that we're hoping are going to be sparked because of this webinar, because there aren't easy answers on that. There is advocacy projects and programs that you could do when you're there to raise awareness to the fact that these issues exist and it is important, and your entity and your leadership are considering it. But at the end of the day, Kristen's right. You're still saying to a subsection of your membership that, you know, we're asking you to come to a place where you're not safe. So I wanted to chime in. I'm going to go back off video, and Mark, if you have anything to say. So thank you.
I do, and I saw that. Thank you, Skip. I saw that question from Jonathan, and it was really good. So I want to, just as an example, when you think in terms of like the bathroom law, you know, that sort of thing. So during site inspections, one of the things that I know that I would do when I was at the section level, but I know that you know, this should be top of mind for everyone, is look around and see if the hotels don't already have, and many of them do now. We've come a long, long way. Gender neutral facilities. When they do that, it's a very subtle and elegant way to point that out by just including a map of the property and putting that on the map, and you're not making it about anything at all except pointing out where the facilities are that people would be most comfortable using, you know, and then it's not a thing. So I think that was one example that I could think of. The other thing is hotels, depending on the groups, you know, they may be able to repurpose, you know, what might have been a men's restroom into a women's restroom if they need more women's restrooms, or vice versa, that sort of thing. So that is, you know, I've seen that happen, and that is certainly an easy thing to accommodate, certainly. The other thing that I sit on the board for the Philadelphia Commission and Visitors Bureau. One of the big discussions that we had recently is, you know, legacy, and what are you leaving behind when you leave a community? And I used an example of, you know, how, and this could apply to like LGBTQ youth, is when you go to a community, you can, you know, go to law schools, go to high schools, go different places where there would be LGBTQ kids. I'm not saying that's what my section did, but talk about career paths in getting to the legal profession. You know, part-time jobs that you can get, or summer internships, or that sort of thing, and make sure that it's just not a big thing, especially to young kids that are still questioning who they are and, you know, what's going on. It's just good to have those conversations with, you know, reach them where they are. And I think that's, you know, the whole idea of legacy is really important to the ABA, and to, you know, these, you know, the kids that might feel disenfranchised, and you know, adults that might feel disenfranchised for any number of reasons. find those opportunities and make them work in our favor.
Thank you, Mark.
And can I jump in on that too, Joy?
Yeah, before you
Little
do, Judge Rossi, I see you posted the link to the Attorney General's website. Thank you for that. Someone has also asked if we could post a link to the exact language of the ABA policy. So I was hoping maybe someone could work on that while you're making your next comment, Judge Rossi.
Okay, great.
Go ahead.
Yeah, I just wanted to because what Skip said about what can you do if you're already going there and the advocacy, and that came up for us at NAWJ as well. And it's trickier. It's much trickier when you're a judge, right? And the kind of political action that you can take and advocacy work that you can take is very different, right? And so we can't go out and make and protest in these states if we're there, and so we do as a committee, we believe that the education portion is important, and that's one of the reasons why we're doing this today, right, is to educate folks. And so we continue to raise the issue and hold panels and talk about the impact of these laws on what, to Mark's point, LGBTQ youth. It's not surprising, or it shouldn't surprise anyone, that LGBTQ youth are overrepresented in foster care, they're overrepresented in the juvenile justice system. And these laws that get passed and, continue to get passed, feels like weekly, have a significant impact on LGBTQ youth. And so I think, to Skip's point, one of the things that you can do if you're going to be holding a meeting in one of these jurisdictions is to actually highlight that and have a panel that talks about the devastating impact that these laws have on LGBTQ youth, especially trans youth. We know that losing gender affirming medical care or mental health care leads to serious mental health issues for LGBTQ youth. And if we care about, all the kids, then we ought to be caring about their mental health and their physical health. And so doing panels, I think, and talking about that issue is important. And that is something that you can do if you are traveling to those states.
Thank you, Judge Rossi. There was, I thought, a thoughtful question from the audience. Is it important to make sure the site selection committee or groups are diverse? Would diversity in the location selection groups ensure consideration of these issues? It might be a rhetorical question, because I think
but it's an important one, right? Because every organization is different, right? And in NAWJ, folks just signed up for the committee that that they were interested in, and I don't. And certainly the members of the site selection committee never felt as, highlighted as they did perhaps in the last year at NAWJ. There's no big meetings and travel group that's making these decisions at most organizations. And so, these are volunteers. It's important to remember that these are volunteers in these organizations. But we ought, and I guess that highlights why we ought to be having diversity in every committee, right? Because certainly, like I said, site selection was never more important than it was in the last year, and I don't think people were really chiming in to be on the site selection committee. Maybe they're not anymore at all after this last year, but yes, I think that that highlights the importance of diversity on every committee.
And if I could add to that too, I staff the Standing Committee on Meetings and Travel. We've just gone through the presidential appointment process, and as part of that process, we are 100% certain that the existing committee that we have right now, which is very diverse, the members that are rolling off, we're ensuring that the next group that comes through, the recommendations that we made in the discussions, we're ensuring the diversity of that committee, and I'm sure all the committees at the ABA are doing the same thing. I just want to make sure there is a process for that, and we want to make sure that that is important. I mean, we know that's important.
Great, thank you, Mark.
Mhm.
There's a question. It's pointed, but I think it's worth talking about. Someone writes, is the ABA suggesting that members should be satisfied with the ABA having conferences in states where I might be arrested by doing other good work to reach out to kids? So you have suggested some good practical things when you find yourself in one of these states, but I guess the question really is, should we be satisfied with that? And if not, what more would you ask of the audience?
That's interesting, because I came up with an off the top of my head example, which apparently did not go well. I mean, this is a very good question, though. I mean, and it doesn't mean that, I mean to dismiss that, someone that goes to a state might feel unsafe going there so that they can reach out to someone else, So my apologies if that's the way that came off. I certainly didn't intend for that to sound that way at all. I think that there's always room for improvement. I think there's things that, we find our way every day in, trying to make sure that we're inclusive and trying to figure out our path and our way forward in the situations that we're in, and I hope that's helpful. I'm not quite sure what else to add to that.
And I think raising the issue, and I didn't take Mark's comment at all to mean that, that we ought to be satisfied. I think that, as an active ABA member, right, I think this is one of the things that we can do, right, is that we can raise awareness on the issues. We can say to section leadership, hey, this matters to me, and I want you to be mindful of it, and you ought to watch the recording of this, and you ought to ask questions about why we're choosing where we're choosing. Is there a reason that we have to go? And this reminds me of something that Joy said earlier, because I give Venice a hard time all the time about the course in Alabama. And I tease him because I can't travel to Alabama as a state employee, but I understand why you're holding the course in Alabama, and it makes sense to hold the course in Alabama. And so, I think that folks ought to be asking the question of why are we going here? Is there a reason for us to be going here, and can we go somewhere else? Can we go somewhere else? Are we holding it here because this is the home state of the person who is chairing the committee right now or chairing the section? Is that why we're going there? And if that's why we're going there, and it's one of the states that on the 18, then can we go to a neighboring state that isn't there? But we have to ask the question, right? And we have to say that we're uncomfortable, and we have to speak up. And I think that, and I think that that's one of the things you can do, is to say, this is the ABA's current policy. If you're not satisfied with that, then say something. Say to your section, to your committee, whatever, why are we planning to go here? And the ABA is great because it plans its meetings out, 5 years in advance or something. So you can see, if it's scheduled in a state that you don't feel safe traveling to, 3 or 4 years out, maybe there's still something you can do. We did not try to move it from Nashville. That would have been a disaster for NAWJ, and that wasn't what our intent was. Our intent was to raise awareness and to say, in the future, can you please make sure that we're protected and we're included, and that we have access to full access. We get that it's here now, but can we please, be included next time?
Thank you. And I would say, many of us are participants, potential participants for some of these events. And if you are choosing not to go, let the organizers know why you're not going. I always appreciate getting that feedback. And if you don't know why someone's not going, you can't act on it. We've got a couple of other comments. We are running short on time, but some of the comments that have come in late have to do just kind of with the economics. with the ability for the ABA to retain membership, for what the business model could possibly be to hold meetings in states that violate federal discrimination policies. So I just want to acknowledge those questions and apologize that we didn't have time to get more deeply into those issues. But I did want to give Judge Rossi and Mark Page one final chance if there's anything you'd like to say as we close this out.
You want to go first, Mark?
Sure. When something that I want to just make sure I circle back to, somebody, I think you and Skip had said that you could put it in the chat area. And I apologize, the Green Book policy on the site selection is in chapter 12, and it's on page 159. I'm sorry, I was trying to like read the chat and I didn't want to start digging through to find that link to put on the in the chat. So anyway, chapter 12, page 159. It's under meetings, the annual meeting, but there's a lot of stuff chalked into that paragraph. So I think your answers are going to be there. I just appreciate very much, the great questions, the passion that I see here. I wish we had more time. I mean, and I appreciate seeing, that people's hearts are in this topic, and that's tremendous. And I totally agree that if you have thoughts, it's funny, we do surveys after meetings for the people that showed up. And as you can imagine, people have a tendency to only fill those out when they weren't happy about something. But I would just say I'm happy to answer any questions that you have, or do the best that I can. My email address is mark.page@americanbar.org. I'm happy to hear from you if you've got thoughts and suggestions.
Thank you, Mark. Judge Rossi?
I just wanted to thank the Soji and the ABA and Mark especially for allowing us to have the conversation and allowing us to talk about the issues and to highlight the NAWJ's what I think is a courageous position to take. I am happy to chat with folks as well. I know many people reached out to me before the webinar even happened, asking about the process and how to get these kinds of things in front of their own organization. So I'm also happy to talk to folks. My email is available through the ABA, and Skip has it, and actually everyone here has it. So I'm happy to chat with folks as well.
Wonderful.
And thank you, Joy, for subbing in at literally the last minute.
Thank you for letting me be here. I've appreciated this thoughtful and collegial discussion on a difficult topic. So our time is up, but this has been recorded. So please catch anything you missed, share this with your colleagues. Thank you to ABA Soji for this opportunity. Thank you, Skip. Thank you, Mark. Thank you, Judge Rossi. Have a good rest of your day.
Thanks.
Thanks, everybody.
Thanks, Mark. Thanks, Skip.
Thanks, everyone.